Hi, Laverne.
Hi, Nancy. I was wondering if I was going to sit here alone. I've been on for a couple of minutes. I hope I have the right coordinates, you know.
I do this a lot. So I'm on the Dover Land Trust, and yeah, same thing. I'm like, wait, did I pick the right night? Is it? And I'm the one that organizes. I'm like, I know I did. Did anyone get the information? I get panicked. Same sinking feeling.
Well,
How are you?
I'm good. How are you?
I'm
I
good.
see Mike is here, so Mike's on. That's good.
Well, I see his name. I don't see his face.
Mhm.
I don't see his face.
Mm.
Busy time of year, right, Laverne?
Yes, yeah, it is. I can't believe how many pumpkins and mums and things and the beautiful decorations on everybody's house. It's amazing.
No, I drive by. I'm like, it's not just one pumpkin. There are
It's
multiple.
10.
It's
Yes, multiple.
and I love you to death, but boy, those pumpkins can run some money when you. I'm like, wow,
Right,
wow.
people, yes, it's kind of it's a lot, yeah. And
It
I
is.
just said that today at lunch. I was with some friends and I said, we used to have a mom and a pumpkin on the front doorstep. Now it's like the houses are so big too,
Yeah,
but
and they have when you see those big forklifts going up and they're putting spiders up, and I'm like, wow, this is yeah, yeah,
different.
yeah. We used to be very different, but I guess we can consider ourselves fortunate. And I look at it as they do it, I don't have to do it. I can look at theirs.
Look at this. I
Yeah,
live on a dead end street and I'm way up in the top of the, not way up, but I'm in
yeah,
the top of it. You can't really see what I have on my front doorstep.
yeah, yeah.
Uh,
Yeah, I don't even know if I don't live on a dead end street, but I don't know. I don't know. Do people really they drive by, they feel like they're driving by so quickly that no
yeah.
one's paying attention to my doorstep. Just me.
Yeah, that's
Yeah,
true. We do it for ourselves.
yeah. Well, that's weird to see the Carroll School with the finally with the windows in, huh?
Yes, and the lights were on. I just drove by there because I went down to look at the 62 Claybrook Road to see what it looked like.
Yeah.
So I came back and I said, "Oh my God, there's windows and lights!"
Oh
And
yeah,
they're
the
working.
lights.
They're working on the old drugstore too, the Dover Deli and Cafe. That's been started inside. The new window
What
is in.
what is that going to be?
It's going to be a restaurant. Jay Hughes has signed up somebody who does sort of holistic, organic, you know, not just subs and pizzas. Supposed to be very good stuff. And they've got a meat market now in the market.
Oh,
Bruce
interesting.
is back.
Okay.
Bruce is back.
Really? Oh, that's great.
Yes,
Although
yes.
my husband's be very disappointed because he loved the Dover Deli. He sneaks over there when I'm not around.
Oh, the
So
Dover Deli. Yeah.
yeah,
So,
so anything holistic with good food is not going to excite him. I'm sure.
well, maybe they'll have donuts or something.
I think
Good
he's
morning.
looking more. He's looking more for subs, Laverne.
Okay.
Hello,
Okay. Hey, hello,
Good.
everyone.
hey George,
Hello.
your dear.
So, yes, hi. Well,
Hi.
we meet again. Yes, at
Very
7 o'clock, we'll have our official commencement, which should be it's 7 o'clock now. Um, okay, the way we, first, this is for the record, this meeting is being recorded. We're using Zoom technology. Uh, and what I would like to do is ask each of our members who's in attendance to identify themselves, please, for the record.
okay. Laverne Lovell, member.
Nancy Green, associate member.
Nadir Ahmed, member.
And Mike's microphone is off.
There we go.
Hi, Mike.
Good. Mike Donovan.
Very good. Okay. And this is George Chimetto. So we have all five of our members, three of them voting members, two of them associate members in case one of us cannot continue with a matter that's under consideration. And what we thought we would do first is have citizens comment if there are any citizens in the room other than the applicant and the applicant's attorney. Are there any citizens, neighbors in attendance? I don't see anyone on the menu here. And okay, well, I think that dispenses with the topic of citizens' comments. I guess what we should do now is open the hearing for the application. And this is for Claybrook Road. Attorney Vinnie O'Brien is here. We're being asked to grant a variance to sideline variances. And our standard for this is in our bylaws, 185-51. There's a public hearing. We're having that now. And we need to find circumstances relating to soil conditions, topography, or shape of the land or structures, which especially affect the particular land or structure, but do not generally affect the zoning district in which it is located. And as such, that a literal enforcement of the terms of this chapter would involve substantial hardship, financial or otherwise, to the applicant, and that desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent and purpose of this chapter. And the Board of Appeals may impose conditions when, if it does grant a variance. That's the standard. And I'd like to turn this over to a person who's no stranger to us, Attorney Vincent O'Brien. Would you please describe the application and what you propose?
Sure, George. First of all, welcome to the board. It's good to see you again.
I've gotten a little older, Vinny.
Yeah, aren't we all? No question. So actually, I want to explain two things. There's basically two applications potentially. The second one is the variance. So the first one, and Laverne would be familiar with this, and I'm not sure what other members. I know Mr. Mike Donovan was on the board a couple of times, but there's a unique statute. When I say unique, it seems to change every couple of years. It's Chapter 48, Section 6. And Dover has a similar statute, bylaw section 185-13. And the background cases on this are enlightening and often entertaining. In essence, what that section says is there's two sections to it. The first section says that if there's an existing use or structure or building, or whatever the case may be, that was in existence prior to the creation of the zoning law, you can't take it away. So, for example, if on the corner of Springdale Avenue and Main Street, there was a little old convenience store, which I think way back when there was. If that was in existence, the board couldn't make it go away, or the town couldn't make it go away because it has a grandfathering protection. A few years ago, so what it basically says, the statute says, and I'm sorry, somebody's trying to call me at the worst possible time. What the statute says is if you have a pre-existing use, it's protected. That's what's called the first accept clause to the statute. Several years ago, the legislature added the second accept clause, and this is what gets confusing. And since then, there's been a ton of cases, but the second accept clause says that there are certain changes to a pre-existing non-conforming use that can be done for 1 and 2 family homes, that the board can make a finding that the changes are not increasing the nonconformity. So, and if they do increase the nonconformity, then the board can find that that increase is not substantially detrimental to the neighborhood. That sounds like a lot of weird stuff and hard to understand, but in simple terms, the standard is much lower than the standard of a variance. Historically, we've had, and I assume Laverne's on here. I can't really see who's here.
I am here, yes, and I remember having a case on this exact house. We had a case on the fellow that lived at 60, and he was adding something on the back. I believe it was a deck or something. It was a while ago.
Mhm.
And at that point, it was deemed that that little cabin that was sort of sitting there, the hunting cabin, was never going to be, that land was never going to be built on. So I don't know what laws have changed since then, but we assured those people that that little, I think Bunny Larkin owned that cabin at one time. Does that ring a bell to you? She was related to Jimmy Mitchell and George Mitchell.
Yep, all those guys own that property back there.
Testing my memory because it was a while ago and I'm getting old. But
Yeah.
I said, I drove by it tonight and I said, I remember distinctly having a discussion about that property. And so
I don't
now we're gonna,
Well, you know, that's helpful, but Vinny, for those of us who don't quite have that history, the applicant that you're representing is 60 Claybrook Road, correct?
62 Claybrook Road.
62,
Yeah.
and this deals with 60. So at the moment, is 60, is there a house on 60 or is it vacant land? What exactly is there?
I just went
Right.
down. It looked like the mailbox for 60 was the house directly across from it. And then this little tiny
Yeah.
cabin sits next to it. You'll have to come and see it.
We
Well,
did a
we're going to have
prior,
a site visit. There's
Yeah,
no
yeah.
question.
we
But
have-
yeah, if you could just describe
So-
this parcel itself, yes.
So there's two different, so I'm just explaining sort of the historical
Sure.
of a finding, and then I'll get into the zoning aspects.
You bet.
So, so if historically what the board had found, if there was a pre-existing non-conforming use and they were going to expand upon that use, then they would make a finding that it's allowed primarily because it's a 1 or 2 family home.
Yeah.
And the board can find that that it doesn't meet those standards. It can make that finding. So what's really interesting, and I'm not sure, George, if you've had an opportunity, but there's a really good case that kind of gives an overview of that. And it's Bellalta, Bellalta versus ZBA of Brookline. And it's just a really good overview.
Hey, great. Just email me that site, okay?
I will.
And that's great.
So this particular lot's a little different than the other ones we've dealt with. And Laverne, I think you remember we did George Schnee up in Turtle Lane, and we've done a bunch of these findings in the past. And typically, not always, but typically what the board finds is if you're not increasing the sideline setback from the existing structure, or you otherwise meet the zoning requirements, then you're not increasing the nonconformity. So
Yeah.
by the statute, all you need to do is do that. That's your finding. You're done. However, historically, what we've done in Dover is, and this is what they've done in the past. I'm not suggesting that's even applies or what you do in the future. Would say, okay, we find that it doesn't increase the nonconformity, and to the extent it does, we're going to issue a special permit because we don't find it's detrimental to the neighborhood. That's fine.
Mhm.
So what has happened and what is interesting is this Belalta case adds another level of scrutiny regarding
Yes.
a variance. So that if the board found it wasn't detrimental to the neighborhood, they could issue the permit without the necessity for an additional variance. Now, that is the standard course of procedure. That's how it moves.
Mhm.
In this particular instance, if that doesn't apply, if the board doesn't find that this property is not increasing the nonconformity, then there would be a request for a variance, and that's
Okay.
and it sounds, when you read the case, it may make a little more sense because I know it's kind of an odd concept in light of the fact that 1 and 2 family houses get a incredibly greater benefit for pre-existing non-conforming uses than would other structures. And
Mhm.
and to add to that, Dover, of course, has some incredibly unique and from a zoning perspective, fun bylaws. And one of them is section, let's see if I can find it here, 18530. That
Yeah.
if there's a lot that's in existence prior to October 1st, 1959, it doesn't have to meet the area or width requirements of a lot, which is absolutely bizarre. But that's
Yes.
Dover in a
Yes.
nutshell.
Uh-huh.
And Dover also has, as many of you are aware, provisions relative to frontage. Often when a town changes frontage requirements, those are valid for about 3 years, typically. Dover has interesting frontage requirements that if you have a plan that has 40 feet of frontage and is dated prior to, I think it's May 1st, 1986,
Right.
it's a lot. It's not a pre-existing. So this is,
That's right.
bizarrely, is a valid lot. Now,
Mhm.
if the board, I'm assuming, by the way, I do assume we do a site visit, which will be helpful. But if
Yes.
the board were to make the determination that this doesn't meet the criteria of 48 section 6, I would suggest it does meet the criteria of variance. And a variance is a very interesting statutory construct. And it's limited to only a couple of different things where a variance can be issued. And those are topography, soil conditions, and shape. And this lot meets actually the frontage requirements. By the prior act, it meets all the requirements, and it meets the area requirements, but it clearly is of a bizarre shape. In
Yes.
addition to that, there is some soil conditions and topography conditions which impact the development, primarily wetlands toward the back of the lot. So what I would suggest is, let's go to a visit. That's typically what the board does. I'll do whatever the board wants, but that's typically what they do. And then in the interim, I can send you that case, which is a good overview of this unique statute. It is really incredible. The statutory, sorry everybody else, but the case law that came down for many, many years, these cases were appealed to the Superior SJC. And it always came down 3 one way, 3 the other way, and somebody abstaining. And it was really interesting. Finally, they've with the Bjorklund case and the Bransford cases out of Martha's Vineyard, they've created a series of case law that gives some direction, but the final and ultimate decision is with the board. But it's kind of a unique situation. That's why I think you find this case instructive. With that said, I believe we meet the requirements of a finding, but to the extent the board felt we did not for any reason, we would then, in that instance, be requesting a variance, and we meet the requirements of the statutorily due to shape, soil conditions, and to not grant it would be a hardship because you lose the value of a lot.
And
Does somebody own the lot? Does somebody just buy that lot? Who's the owner? and What they pay?
The guy by name of Lawrence Fish had owned it for a long time. He sold it to somebody a couple of years ago. They defaulted on a mortgage. He foreclosed on them. I'm just trying to, and then our clients bought it. I think I have. Within the last 2 years, I believe. I'm sorry, I have the deed here somewhere. But it was owned for a period of time from 2021 to I think 2023 by Dover Mill LLC. They got foreclosed on, and my clients bought it subsequent to that.
And your client is Michael Stalling.
That is correct.
Ben, do you have a plot plan that you can show us? I didn't see it, any plot plan in any of the text.
I thought I provided one with the application, but I can certainly.
So I have a plan, but I don't know if I saw the
two
actual.
of the house. Yeah.
Yeah, none of the plot.
Okay, what I can do, I can either drop off copies at the zoning board, or I can scan them and email them to George, and he can upload it to everybody else, whatever's convenient.
That would be fine with me, and I'll distribute and also give a copy to Felicia, our town clerk.
I have a couple of different things that might be helpful. One, I have the original plan creating the subdivision, and typical names, Mitchell, all over it. And that was in 1922, so it meets the statute requirement prior to October 1st, 1959. I also have a plot plan showing the existing structure and the proposed structure overlaid over that. And I have a plan that was submitted to both the Board of Health and the Conservation Commission. And that shows some of the other setbacks and things that might be relevant. And I know they were before those boards. I'm not sure of the final analysis there, but I will report back on that once I speak to my client about it.
Could we also
So
get, sorry, could we also
That's all right.
get the, a write-up of what you just shared regarding the kind of application of the statutes as you've just sort of outlined them?
Yeah, I can give you a narrative because
That'd be helpful.
it is a little confusing. And, you know, just kind of reading that case is helpful, but I'll give you an outline of that. Because the case law has evolved a lot, and it is a bit confusing. So I get it.
And then
Yeah.
can I just confirm that the current structure, that's a shed, not a house? Or is there sort of plumbing in that facility?
I'm not exactly. I think they used to call it a camp in the old days. I'm not exactly sure what's in the structure now. I can find out. I'm not sure myself. I just see the engineer's plans. I haven't been out to the site myself either. So
So you, oh, go ahead.
Just going to ask, is this owned by the same individual who owns 60?
I think he owns 60. I think he owns an abutting lot. I think it's 60. Yes, I think he lives and he bought this 62.
Yeah, because
Yeah.
we previously addressed 60, I believe, to add a second floor and then a rebuilt
Right.
Shed or garage, I believe.
Which would have been
Yes, did that with the garage in the back. And maybe
right.
that was the time when they said this other parcel was never going to be built on, and that shed was abandoned. I like that word, abandoned. We just went through that whole abandonment on 8A Farm Street.
And if I'm not mistaken, part of what our view there was that the lot wasn't built to be built, and that there was sufficient space between, because I think the side setback on 60 didn't meet zoning requirements, and therefore there was sort of a sense that it had additional space on the other side because the other lot was unbuildable. But okay.
that I don't know, and I wasn't part of the application. I'm not sure it's in there. Under with that other lot, that sounds like the exact perfect example for what we call a 48 finding. Basically, have a pre-existing non-conforming lot. There's almost nothing you can do that's not going to make it more non-conforming, right? I mean, there's almost nothing you can do. You couldn't add a square foot to it. So the statute takes into consideration that kind of circumstance, that there's and it's kind of discussed in the case, that's why I think it's a good case. There's a balancing act between an overall desire, and this is where the Supreme Court went back and forth. There's an overall desire to have uniformity of zoning, but by the same token, there's a understanding and respect for retaining the rights of people in pre-existing properties and not take those rights away and make them non-functional, for lack of a better description. The case says it much better than I do.
And I guess did the buyer of the lot have a sense that this was a buildable lot? Because it seems as if it was a relatively recent acquisition, and so they presumably would have purchased it as a non-buildable lot at a significant discount. So I just want to make sure I understand sort of the financial or substantial hardship kind of.
I don't know. I mean, if he didn't come to me, so I don't know what and I didn't represent him in the sale, but what I would have said to him is kind of what I'm saying to the board. If there's a pre-existing structure on there, the board can make a finding that you can increase the nonconformity. If there were no structure, if nothing was on that, if it was a completely vacant lot, I would say from my perspective, it's entitled to a variance. The shape of the lot and the topography alone meet the standards of a variance. Otherwise, you have a lot that's worth nothing. But that's the board's ultimate decision to make. And the standard for a variance is greater than the standard for a special permit.
So Vin, I'm on the Dover Assessor's map record. It doesn't show a building. It doesn't speak of a building on 60. It just speaks about land. There is no building. There's land that's worth $72,000, a yard that's worth $4,000, and building is 0. And there's no building recorded.
When I saw it, I couldn't get into it. All I saw was he called it an outbuilding, which they refer to all the camps on Claybrook as outbuildings, whatever that is.
Like a shed. Yeah,
Not a
hunting.
shed, camp. There used to be a lot of camps over there in the old days along the river.
So the town wouldn't acknowledge that as a structure or a building, a camp?
Well, it's definitely a structure. Sorry, I'm going to get a charge and my phone's about to die, of course, right? There is a structure there. We can take a look at the nature of the structure. And to the extent that it doesn't meet the requirements of 48 Section 6, and therefore would be deemed a vacant lot, it would still, in my opinion, meet the requirements of the variance of shape, topography, and soil conditions.
Okay. Yeah, I think a site visit would be really beneficial for all of us.
Yeah, I agree.
Okay, and on that, just timing wise, it could be an application for a permit. It could also be a variance. And if the variance is what we are going to consider, there's 100 days from the day the appeal was filed for us to have a decision. It's not like a permit where you have time after the hearing closes. Correct?
I will tell you this.
And so I'd like to get an extension for the
Yes.
time to issue a hearing, to have a site visit, then to deliberate, and then to render a decision. Now, the time technically would be up October 26th. And board members, first, what is your availability for a site walk? And whether that's weekends only, during the week, early mornings, what would be best for you?
I can do early mornings. If that
Yep.
works for people.
I could do that too.
Early mornings, preferably Monday or Friday for me, just because I go into the city on Tuesday, Thursday, Wednesday, Thursday.
Okay.
Okay, and what is early? Are we talking fishing early or second cup of coffee early?
7, 8, whatever. Yeah.
8 maybe?
8 would be
8
fine.
o'clock.
Better
Needs
for
a
me.
second cup of coffee.
Yeah.
Mhm.
Good, so that would be 8 o'clock on a Monday or a Friday,
Mhm.
and, well, so, and we do need, I believe we need to, have 48 hours notice, even though this is, technically, we're not going to deliberate when we have this, so it's technically not an open meeting, but I
It's
think,
not a meeting.
shouldn't we give 48 hours posting?
I think you can post it. I don't think it doesn't have to be published. It's not a meeting. You
Yeah, it doesn't have to be
typically
published,
don't
I
take,
agree.
general questions, but you're not taking testimony like, where's this, where's
That's
that? But
right. Okay, so if we did that and, just looking, would Friday, the 11th, work for everyone at 8 o'clock?
I'm not gonna be here, but I could do Monday, the 7th. I could do
Okay.
tomorrow. Oh, we have to post it for tomorrow.
Yeah, I
that's-
can't do the
that's
7th.
kind of tight.
Um. I'm gonna be gone for 5 days.
Oh, are
So-
you? Okay.
So
Um,
maybe we do it some evening, like at 5:30 when Nadir gets back.
It's dark.
Who-
It
It's
gets
dark.
dark pretty early
It's
now.
dark, yeah,
I mean,
you're right.
Yeah,
It's not a big camp, so
Yeah. So, what about, I can do Wednesday, the 9th.
I can do
Work it out.
Wednesday the 9th too.
That's
Yeah.
good. I could do that. Yep.
okay, that works for me. And so that would be 8 o'clock, Wednesday, the 9th,
8 a.m.
and I'll ask, Alicia just to post something.
And we're going to the lot on 62 or 62, yeah?
Yes.
Yes.
Okay.
No, the applicant, the applicant is 62 and LLC,
Well, the lot is 60.
which has an address of 60 and the property is 62.
Correct.
Okay.
Is Mr. Stalling gonna live in this new house if he builds a house there, or is that gonna be resale, or is it gonna be rental? Do we have any idea what he's gonna do with it?
I don't know. I can find out. I can ask that question.
Because they have, all these things about putting in an ADU if he wanted to do it, the additional dwelling unit, something like that. Wouldn't need all this. Maybe you have to go through all this. How big is this house that he's gonna build? Or is
Not very
looking at?
big. It's 32 feet by 43 feet.
Okay, 32 by 43.
Sorry, but what's the square footage intended to be?
That is just the,
I thought it's all
Solid.
3 bedroom,
Yeah, it's
3,300.
something like that. Is that right?
3,350, something like that, yeah.
Yeah, and part of that is, within that is a two-car garage that is 23 by 24. So that eats up a lot of the square footage.
Okay, now, we should also be thinking of when would our next hearing date be? And, we do have, an application for this, Airbnb, short-term, tenancy for 25 Dover Road. And our deadline for that would be, let's just see here. November 19th. So we're going to have to meet before November 19th unless we have an extension of that matter. I don't know how much time that is going to take. And we'd want to give this applicant time also. So if we set up, I'm just wondering, how about maybe Monday, November 18th in the evening? That could be ideally cover both matters at that hearing, or I just don't think the Airbnb application should be the sole thing we need to focus on.
You had put it in your memo, maybe November 7th, I wrote in my book, was the number
well,
you had touted out.
well,
in one of
I
emails.
think, yeah, for that
Soon-
we could, those really deal with, publication times because,
Oh, yeah,
first we set the hearing deadline, and then we have to backtrack at least 14 days and take into account the paper only publishes on Thursdays. So that's an advertising headache. And, and, but I'd say here, we'll need, if we're going to have a hearing after this, uh, whether we decide at that hearing or close it and then ask our counsel to help us interpret this case, and I'll look at this and share it with you before that. We may need to actually have a date for the decision that goes so that we would have the hearing in mid-November, but we would need at least maybe 2 weeks uh, to write up a decision, or maybe even meet again. Open meeting law is a wonderful thing, but it does prevent some efficiencies where we really can't, decide these things on emails. Benny, what's the timing with your applicant? I hope he's not expecting something the day you
George, as I,
close.
as
Yeah.
I you in the past, and Laverne knows, and other boards know, I'm certainly willing to give you whatever reasonable time you need, and I understand a number of different things. One, I know that you're new to the board, and I take that in consideration in a positive way, not in any negative way, but you're taking on a mantle from some interesting and historic figures over the years, including Henry Minot. So
Because I have good fellow board members.
you
Otherwise,
go.
I would not be here. It's so good to have this institutional memory
Yeah,
and
that's
good questions. Yes.
I want you to. What I don't want, by any stretch of the imagination, is undue pressure on you and undue pressure on the
Thank you.
board to be forced to make a decision. I want this to be, an open discussion. These statutes and these regulations create guidelines, and that's what they are. They're
Thank you.
guidelines. But with anything, there has to be some understanding that, especially in a kind of unique situation like this, unlike some of our typical finding cases, which were a little more straightforward, that the board needs to be familiar with the property. And more importantly, and listen, I've been doing this for 40 years.
Sure.
I read the cases and they're confusing to me. So when the board members say, can you give us a little outline what's going on? I get it. So yes,
Yeah.
the board can get whatever reasonable time they need. You're never going to have a problem with me.
Well, thank you. What we'll do, we will swap something, but I'm thinking with a decision date of October 26th, if we extend that by 90 days, that gives us time for a site walk, more hearings, and ideally have a decision within those 90 days.
But then the board has comfort not knowing they're under the gun.
That's right.
Yeah, no clients are ever happy with extensions, but I'm fine with that.
Oh, okay.
And
Thank you.
hopefully,
Yeah, the alternative is not really
yeah.
good.
Oh, I know what the alternative is.
That's right.
That's,
Yes, I
like
know
said,
it.
and there is, it sounds weird, but most case law is pretty dry and boring. Some of the stuff's hilarious, almost the
Yeah.
way it's written.
Yes.
Because it's such a unique statute, and it's only to 1 and 2 family dwellings that gets this special second except clause protection. So
I think so. I'll prepare that. We'll swap it, put it on file with Felicia, which is what we do.
Mhm.
We're going to have then a site walk, and we got that scheduled for Wednesday the 9th at 8 a.m. And I think at that we can decide when is the next time to have to continue this hearing. And it would make sense to me that we coordinate that with the time for the 25 Dover Road Airbnb, that we do both of those the same night.
Okay.
Okay.
And
Good.
Nancy-
Well, listen.
I'm sorry,
Yes,
George.
Nancy.
Yeah, George, did you want to do did we say we're gonna do that on the 7th, or you're gonna push out now, November 7th, the
Well,
Airbnb?
well, the Airbnb, unless we get an extension, we really, our Airbnb, time again is, November 19th is the deadline for the hearing. And that's a special permit case where, as long as we have the hearing by the 19th, we've got 90 days after the hearing concludes to issue a special permit. So it's different. Special permits run from the conclusion of the hearing, whereas variances are 100 days running from the filing.
Right.
Yeah, that's
And we're
that
kind of
is
our primary request is for a special permit. So
yes.
I want to at least give the board the same consideration that they would get under a special permit in light of the fact that we may be
Right.
in the alternative of getting a variance.
You know, and that is good. Vinny, when you prepare something briefly on this for us, although actually as much detail as possible, you know, please cite where in the bylaws is the special permit that you're requesting. I know we've got a grid. There are a whole bunch of things that have a P for permit, but you know, that would be helpful just so we're honing in on what you would like,
So
as
here,
opposed to just being a variance.
yeah, there's absolutely nothing in your bylaw
That's what I thought.
that says,
That's
but
why I asked.
there is statutory language for MGL Chapter 48, Section 6. So,
Okay, yeah,
and it has even evolved further from the last time I did this, but it is. I will try to synthesize it as much as I can and provide the relevant case
well,
laws that
see,
cases.
and that's important because yeah, our bylaws coexist with the state law, and the state law overrides in certain areas. And I think, uh, for example, when there's a building inspector denial, I don't know in our bylaws if the 30-day time to appeal that even appears in our bylaws. It's in the state law.
Well, just as a
Yeah.
quick aside, and I've had this discussion with Gary Lilienthal and Alan Fryer, two of your predecessors. If I'm seeking a finding, basically, I'm acknowledging
Yes.
I don't go to the building inspector. I'm going to you guys first. So
That
I'm not
is
sure the 30
right.
days even applies.
You know, I agree with you. In fact, we actually faced this with a prior application asking for essentially a finding of grandfathering with no variance at all.
Right.
And yeah, the 30 days, at first it was a heart stopper to think about that, but actually it doesn't apply. You're asking for a finding.
I'm asking
Just
you
like there's, yes,
and the building inspector can't issue the permit without you making that finding. So,
right.
so conceptually, I'm not appealing his decision. If I'm appealing it, I'm saying he's wrong, but he's right. So I'm not
Yeah,
really
yeah.
appealing his decision. I'm asking you guys to make a finding that he can make his
Exactly.
decision.
And you know, and thinking in the case where there could always be someone who wants to contest from the neighborhood for whatever, you know, that and you filed within 30 days of the
Yeah.
denial. So it's a moot point for you. You did it.
I do it that
but-
way, and you know, I'm by the
Yeah.
statute. All I need is a finding, but I ask for a
Okay.
finding permit,
So,
and then the
and so
variance, I try-
essentially we're looking for a special permit, which is itself not really specifies as a permit matter under our
Right.
bylaws, but is so defined under the general laws. That's very helpful to know.
torture.
And-
Wait till you read this stuff.
Can I just clarify? So
Yes,
what you're saying is you really, I mean, you went to the building department. The process, you go to the building department. He says, no can do. Then you've got to go to the zoning board. You're suggesting that you already knew that it's going to be a no. You could just skip the building department and get us, apply for a special permit from the zoning?
Yeah, so that's technically what we can do.
Yeah.
Technically, right? Because when I go to the building department, if I have a pre-existing non-conforming lot, he says I can't issue a permit. I agree. So I'm not really appealing. I'm not
Yes.
saying he did anything wrong.
Right,
However, the process has always been appeal the building department, but technically, he's right.
That's,
He can issue the permit. So
that's right.
it's one of those procedural things where let's look at it a different way. Let's assume I applied for a building permit, had a valid lot, and for some reason he denied my permit, and I think he's wrong. All right. Like he says, I need a 30-foot setback, and I really only need a 20-foot setback. I'm saying he's wrong. That's appealing the building enforcement officer, and I'm going to the board to make a decision whether they're right or wrong. Correct?
yeah.
Here, I know
You're wrong.
well, not so much wrong, but I know that
Yeah.
he doesn't have the power to issue that permit. Now, interestingly enough, prior to some of these cases, and that's where it becomes really weird, prior to many of these cases, if you had a pre-existing conforming lot, the building inspector, if you stayed in the same footprint, would just give you a permit. He wouldn't make you go to the zoning board of appeals. One of the cases here, it's an existing house and an existing foundation, and they're adding a dormer. The building department said, you got to get a finding. So it's a really interesting and, like I say, sort of evolving series of cases. And especially in the last 15 years, it's been wild. So I'll like I say, I'll try to do an outline that kind of makes sense and provide
Yeah.
some of the backup cases, and both on the 48 section 6 finding language, which is pretty liberal,
Yes.
and alternatively, separate from that, if that's not found by the board for any reason, I will then secondarily, as a backstop, put together information on the variance.
That
Again, trying
is
to elucidate the important elements of both for the board.
excellent.
Can you also look up when that camp was built? Isn't there a grandfathering clause in a nonconformity?
So if you have, you're right to some extent. So let's assume, wow, this is an interesting case that I had. Let's assume the lot was created. I'm trying to think. See, Dover's so weird that I don't know how else to explain this. If we were in another town and they didn't have the statute that you have a valid lot created prior to October 1st, 1959, so that you had a pre-existing non-conforming lot or a pre-existing non-conforming use, and you abandoned it. If you abandon that use, you might lose the use and lose the pre-existing non-conformity. Interestingly enough, there was a lot on Farm Street that had no frontage at all. And there was a house on it, and nothing was done there for a couple of years. And the question was it abandoned? In that instance, that lot had no frontage. It could have been abandoned in theory. Here, and therefore, its non-conforming status is lost. This is a valid lot. This is not a non-conforming lot. The structure is non-conforming, but it's a valid lot. It's weird, and I've never seen a statute like this anywhere else in any other town. But if you have a lot created on a plan prior to October 1st, 1959, that's a building lot. It's a valid lot. It's weird. Usually lots that are of this nature, if it's combined with other neighboring lots or other properties, there's a doctrine called merger. And once the lots are combined together in common ownership,
Right.
those lots are gone. Now you have to meet the current zoning. This is unique to Dover, and they've done it 3 times. They did it with the 1959 lots. They did it with the 40-foot strip in 1986.
Yeah.
They did it with a 100-foot strip, I think, in 1989. And then they got rid of all those things altogether. But those lots are valid lots,
That's right.
which is so unique.
Forever.
Yeah.
It is.
And I know some of the older attorneys in town and the town founders wanted to protect the inhabitants of the town at the time, and they structured it exactly that way. So the David Lewis and the Henry Minets and the Jack Donahue's, all those guys, were trying to protect the people who have these lots for hundreds of, sometimes hundreds of years, or in the family for many, many generations. So they're protected. That's the only idea I have. That's why they did it. But they're different than any other town.
Yeah.
Any other
Those
town,
were
if
the
you-
days when some people actually wore evening clothes to town meeting.
Yeah, exactly. Yes. Yes. Those were the days. So,
Gee. Okay, listen, for timing, October 9th, 8
Yep.
a.m., we've got a site walk.
Yep.
We have a deadline for this other matter of November 19th. So anytime up to November 19th, we could have a follow-up meeting for this and also schedule the special permit. So I guess we'd need a little bit of time after for a 48. Well, we're going to continue this hearing. So it would be sometime after the site walk and before November 19th to handle both these matters. What would look good for you? What evening would look good? Somewhere between the 9th and November 19th.
Vin, you're muted.
And we could move this along and schedule for, say, the 17th if you like.
Vin, you're muted.
Yeah, I like the idea of giving us some breathing room in the event that we need
Sure.
information
It
or
could be the
follow-up.
20. What would you like? What day would you all like?
whatever works for the board. Hopefully I'm unmuted now. I'm very comfortable. Whatever works for you. If you
Great.
guys want to tentatively say the 19th, and between now and when we have the site visit, you decided there's a better day for the board, we can amend it to that date.
Okay, well, 19th is a Saturday. So yeah,
we're
but
using
that's great. Yeah, because I think at this, we do need to continue to a specific date, even if we move it later.
Okay,
How about
Yeah,
the
so-
24th? 24th of October, Thursday.
And let me just see here. That
That looks,
actually, you know what?
That week's going to be tough for me. Sorry.
Okay.
Okay,
so what happened to the 7th? We've given up on
Well,
the 7th.
Well, the 7th,
the 7th of November is possible.
That was what you had I've got it written in my book because we had sort
Yeah.
of talked, or the 6th.
Yeah, if the
Well,
7th works, that's fine.
I can
That's
do
a Thursday.
I can do every night the week of October 14th except for Tuesday.
Okay. That would be the 17th
Yeah, that works.
of
17th.
October.
Of
17th.
October.
Yeah, that works for me.
That works, I can do that.
And
Okay. So I'm
Laverne,
canceling.
are you there? You're there on October 17th also,
Yep,
everyone? And Mike, how about you?
I'm open.
Okay, good. So let's reflect. We'll continue this hearing until the 17th, and we'll have a site walk on the 9th at 8 a.m.
excellent. Great.
That's good. Oh,
mind.
that's good.
Okay, 9th and 17th, you got it. You're in my
Great. And,
book.
George, does that give us enough time to get the notice out?
Well, to continue the hearing, we would only notice that 48 hours. In fact, I'm not sure we need that notice, although I think it's just good practice. But we don't have to go to the paper again to continue.
So are
No,
we gonna
okay,
do,
but- but,
are we gonna do the other
hold
one,
it.
the Airbnb? at the
Yeah,
same
yeah,
time?
hold it. That's a good point.
Now, we don't have 2 weeks for that.
No,
Just
we
to
don't,
get-
we don't have enough time to do
Yeah.
that one, so we could do that at a different time. I mean, I think, and I don't expect, frankly, we would have much trouble continuing the other, but yeah, this is, to get this into the paper. The earliest we could get this into the paper is gonna be, publishing on the 10th. And so that means we really have to meet, later than the 24th.
Got it.
Uh, if we're gonna do both at one time.
Can we do 29th? The
29th?
The 28th,
28th or 29th?
28th would be better for me. If
Yep,
we could do that.
I'm open on the 28th.
Hey, okay, Monday, the 28th, great. That's why, that is excellent. Okay, so the 28th,
And we'll have 2 hearings that night,
that's correct,
okay?
both hearing dates. Okay, and that also gives Vinny some time to get us something,
Some stuff to
and
look at.
That's great.
we all get to read this wonderful prose from the state courts. Okay, that is super. I think at this point, Vinny, you're welcome to hang around if you like, but
I'm
we're
going
gonna-
home, but thank you very much.
Okay.
See you
Bye,
all.
Well,
Vinny.
listen,
Cheers.
it
Bye-bye.
is good. It is good seeing you.
Good
That's
seeing you, George. Cheers.
okay. Um, so then I guess next, uh, what we have, August 1st, I thought we had approved everything for March. I wasn't here then, but we approved, or the two of you who were there approved the March 16th minutes, but there are minutes for March 26th that need to be approved. And I should have sent these to you a few days earlier. I don't know if you've had a chance to read them, but what we need to do is, approve them if they meet your approval. If not, we will address them at our next meeting. And then as far as just scheduling generally with minutes, the third practice, and I'll try my best to move us to that. We've got Felicia, who is really wonderful. Would be to have minutes and approve them at the following session, if that's at all possible. Under the state law, you've actually got 3 meetings after the meeting to approve, or 30 days if more. But for us, it's going to be actually 3 meetings following the meeting is our preferred deadline, after which someone really could complain. But we'll now that we're all working together, we can move these through faster. But I think here, if you like, those of you who attended the March 26th meeting, if you'd like to approve those minutes, we can do that and have them finalized.
I've
It came
reviewed
to
them.
me-
I've reviewed them and they are consistent with my recollection of the meeting, so I think they are ready for approval.
Excellent.
I make a motion to approve the March 26th meeting minutes.
Excellent. All in favor?
Steph?
Second.
Yep.
So moved.
Okay. That's excellent. Well, thank you. Felicia does a fabulous job. My goodness, she does. It's more detailed than I've seen in minutes in any organization I've ever been with. That includes public companies. But she's a wonderful resource. Let me just talk to you a little bit and about just general organization. Chris was our initial person to help, but I guess he's very tied up and is really not available to us as a resource, which I think actually is going to be fine. I mean, he helped us with the Zoom, and fortunately, and when I spoke with our counsel the other day, just to Nina, she observed that we are the only zoning board of appeals she knows of that doesn't have dedicated staff.
Mhm.
and I apparently that a lot of this is really clerical, just getting the notices done on time, published, and we're lucky with Felicia. In fact, I think I'd be inclined to rely on Felicia and also you rather than a younger person who is split between different missions. I mean, for example, our town planner, I think this would be overload with her and actually I think Felicia is going to give us a lot of support. For other things, I think my own preference, but I may be alone on this. I wouldn't mind us once in a while meeting in person. It's a little without cameras. It'd be a public meeting and it'd be noticed, but it gives us a chance to really get into some of the administrative details more and discuss things. But I don't have kids at home, and I understand what that is not here. Make sure we did not schedule this for October 31. You're probably out trick or treating, right?
Right.
But I think otherwise, I think we're actually I'm feeling more comfortable, and it's just such an enormous help that you have memory of some of these things. I pulled with Felicia's help some decisions, variance decisions, but I don't have what was decided for Claybrook. And so those meant that decision is kicking around, and I'm going to ask for that. Does anyone have a copy of that themselves? The Claybrook decision?
Well, it wasn't actually a
draft.
decision. I don't think it was a decision that we made.
Was.
It was
Yeah,
that we
we
were
had-
at that house discussing was it a discussion, Nadir?
We made a decision related to 60 Claybrook to
Yeah,
increase
yes.
the height and then
Exactly.
Yeah.
The guy
replace the
was-
garage. But yeah, Laverne's exactly right. We didn't.
Yeah,
I don't recall the decision referencing the other lot, but it was definitely part of a discussion when we were doing the
Okay.
site visit. As
Yeah.
part of because it was bumping up against the side setback, and I think the view was, well, there's a lot of other space on the other side because that lot's unbuildable, so it's so far.
I see.
That's right.
There was some
That's right.
Laverne, I don't know, or Nancy and Mike, I don't know if you recall, but there was some representations I thought about the shed and how I remember that being kind of a specific topic of discussion during that
Yes.
visit.
There
But-
was. I don't remember what exactly it said.
Well, this site visit is going to be good. I'm surprised there aren't some neighbors who showed up on this, and maybe they don't really quite understand what's going on.
Yeah. Yeah. But they must
Because,
have all got
this-
the butters. They got a butters notices, right? But
Yes,
really, if this guy owns the
Yeah.
house, it's only the butter on the other side that would even care, or know about it. Because
yeah,
this butter is owned by Stallings,
Yeah.
whatever.
well,
So,
I mean, we, advertising and sending to the abutters is fine. One thing that's kind of funny that we don't observe is the parties that need to be notified for every one of these things are the planning boards of the abutting towns. I asked Nate, I said, gee, do we do that? And she said, no, a lot of towns don't. But, in speaking with Carol, apparently the planning board is peppered with notices from other towns.
Oh, really?
So, there's no question that is in the statute. I mean, it's certainly common sense. Why bother another board when something is nowhere near the boundary? But anything that is close to a boundary, a town boundary, I think we would notify that adjoining planning board, because that is in the statute. It's not an either or. It is just as important as the butters under the statute. Yeah, it's crazy. It's amazing anything gets built in Massachusetts with all these laws. Okay, is there anything anyone else would like to talk about, or do we next see each other with our hiking boots Wednesday morning?
And a cup of coffee.
That's right.
Good. Okay. I like that spirit, Nancy. Great. Okay. May I have a motion to adjourn?
So moved.
Okay.
second,
All in favor?
Aye.
I
Okay. Hey, thanks very much.
Thanks,
See
George.
you
Bye,
soon.
George. Thank you so much.
Thank
See
you.
Next Wednesday.
Okay, bye.
Okay, thanks. How do I leave?